Hi, I'm Peter Tragos, host of the Lawyer You Know podcast and YouTube channel. The saying goes, everyone hates lawyers until you need one. Well, I'm here when you need one to answer your questions and give you insight that you didn't know you needed. Along with my partners, Pete Sardis, the professor, who has a finance and business background, and George Tragos, my dad, and the consigliere, a criminal defense giant, we can answer any questions you have. Welcome back in, everyone. And as promised, we are going to do a reaction to the 2016 video deposition of Amber Heard that we saw, at least bits and pieces of it, come out during the trial, and I think was incredibly damning for impeachment purposes for some of the things Amber Heard said on the stand. So if you're here for this content and you enjoy it, please take a second, hit the like button, and make sure, because this is a static video, it is not a live. I'm not going to be answering your questions live. Let me know any questions you have in the comment section, or if you are watching the premiere and get in the live chat, I will try to be in there answering questions as well. So we're going to have some fun talking about this and seeing kind of what went wrong during this deposition, seeing how her demeanor was way different than what we saw at trial. That's one of the biggest things to me, is how different her demeanor is in 2016, which is after years of abuse, being in this relationship where she suffered at the hands of the monster Johnny Depp over and over again. Let's keep that context. This is after all of that. And this is during should be what's a very emotionally difficult time for her, going through the divorce with Johnny Depp in 2016. And, 2 years later, she writes that op-ed. So let's keep all that context in mind when we watch her demeanor, how she says things, because sometimes how you say things on a video deposition are just as important, if not more important, than what you say. And that's why you choose to video certain depositions. Not every deposition is videotaped. They're all typed out and transcribed and things like that with a stenographer there, but only certain depositions, strategically chosen depositions by lawyers, are videotaped. And this was one they videotaped. A lot of them, if you think you're going to use them for trial, that's one reason. But this one, I think they knew could potentially come back to bite her in the future, even if it was not in this specific case, but in some case. So let's get into the video now. I am going to be watching it on Incredibly Average's page. He posted it with Jax. I watched it on there. I'm one of his 100,000 views, like I said. So we're going to watch the deposition. I'm going to give my reactions to it. I may skip parts where they kind of break and talk. I'll probably jump past those parts so the video is not 3 hours long. But let me know in the comments in the live chat what you think as we watch this video together.
Good morning. We're on the record. This is the recorded video deposition of Amber Laura Depp in the matter of petitioner Amber Laura Depp versus respondent John Christopher Depp II, taken on behalf of the respondent. This deposition is taking place at 2049 Century Park East, Los Angeles, California, on August 13th, 2016, at approximately 10:01 a.m. My name is Stan Beverly. I'm the videographer with U.S. Legal Support, located at 11845 West Olympic Boulevard, Los Angeles, California.
So just a little pause there. U.S. Legal is who we use for a lot of our depositions, and they're all over the country, and they're great.
Video and audio recordings will be taking place unless all parties have agreed to off the record.
Where Charles?
Okay. Would all present please identify themselves?
Yes, good morning. Blair Burke on behalf of respondent Johnny Depp.
Hans Ballhoff on behalf of respondent Johnny Depp.
Laura Wasser on behalf of the respondent Johnny Depp.
We recognize that name. That was the female family law lawyer that was deposed, and we saw her deposition by video in the trial. And you see a lot of lawyers are going to be here.
Samantha Klein on behalf of respondent Johnny Depp. Lisa Sutton on behalf of respondent Johnny Depp.
Carrie Garbus Wright on behalf of respondent Johnny Depp.
Patty Glazer on behalf of Mr. Depp.
I've lost
It
count.
being 10:02, correct? We are ready to begin.
A lot of lawyers.
It appears that petitioner Amber Laura Hurd has not shown up for the deposition ordered by the court
She's late, go figure.
for today, nor has
Shocking-
any
shocking
of her legal
developments.
representatives appeared. We can go off the record.
So her lawyers didn't show up and she didn't show up. And in most jurisdictions, like here, if you're 15 minutes late to your deposition, you can do a CNA, a certified non-appearance. Take that to the court. The court reporter will give you that. So everybody shows up. We started the record. We have the time. You get that document typed out. You bring it to the court or file it with the court, and you try to get the court to hold her in contempt, sanction her, do something to punish for her wasting everybody's time, the court's time, the court reporter's time, and not showing up for her deposition that she was served for. That, or if she wasn't served for, then her lawyers probably agreed to make her appearance or to have her come and show up for this deposition, and then she didn't do it. So they will still ask for punishment, sanctions, whatever it may be, contempt, if they get a CNA, which I don't think they do, but I've never watched this before. So we're watching it for the first time together. So I don't know if she shows up a different day or if she just shows up late.
The time is approximately 10:02 a.m. and we're going off the record.
So it looks like it's the same day, just 5 minutes later. So maybe she was 7 minutes late or something. I don't know what time the depo was actually set for, but she does eventually show up.
The time is approximately 10:07 a.m. and we're back on the record.
Thank you, Blair Burke, on behalf of respondent Johnny Depp. It being 10:08, and we are now back on the record, having gone on the record at 10 a.m. for the court-ordered deposition of Amber Heard.
So that's even a step up. It is a court-ordered deposition. So if she didn't show up for this, you better believe there would have been a contempt hearing and sanctions, and it would not have been good for Amber Heard. But in the legal field, everybody's late, everybody's overworked. So 5 or 10 minutes usually is within the grace period, which is why we always have to wait 15 minutes before getting a CNA.
Ms. Heard is apparently now here with her counsel, and if we could please have everyone introduce themselves.
They always take shots. She's now apparently here.
Charles Harder for Ms. Heard.
Joseph Koenig for Ms. Heard.
Samantha Spector for Ms. Heard.
Chris O'Donnell for Ms. Heard.
Leonard Levine for Ms. Heard.
I'm sorry. The certified court reporter is Pam Felton. Would you please swear in the witness?
So that was 5 lawyers for Ms. Heard. Johnny Depp had more than 5. So, I mean, 10 plus lawyers sitting at this table. It's just, it's wild.
Would you raise your right hand, please? Do you solemnly state the testimony you're about to give in this deposition will be the truth, the whole truth, and nothing but the truth?
Yes. Good morning, Ms. Heard.
Good morning.
Ms. Heard, I'm going to be asking you some questions today. Would you prefer that I call you Ms. Heard or Ms. Depp or Amber? What would be your preference?
Ms. Heard is fine.
Ms. Heard? Okay, I will do that. Ms. Heard, this is a proceeding in which you're about to give testimony, and it is known as a deposition. Do you understand? Okay. Our purpose in taking your deposition is to obtain the facts, the true facts and information within your knowledge related to matters involved in this lawsuit or proceeding. We did not seek to trick or to trap you in any way. We do not wish to cause you discomfort. The person transcribing the deposition is a certified shorthand court reporter. At the onset, you will be placed under oath. Do you know what that means?
Yes.
Okay. You will then be asked questions which you are expected to answer fully and truthfully. Under oath. Please do not guess. We request your best present recollection of the facts and events about which you will be questioned. We will presume, therefore, that whatever you testify to today is your best present recollection and not a guess. Do you understand?
Yes.
Okay. Although this deposition is being held in the informality of these law offices, this deposition does have all the solemnity of courtroom testimony. Since you're under oath, your testimony here today will have the same force and effect and be subject to the same penalties as if you were testifying in a courtroom before a judge.
Like perjury.
Do you understand?
Yes.
If I might ask you not to nod your head and instead answer yes or no.
This is all the common stuff we open every deposition with. The court reporter can't take down a nod. You have to answer verbally. Do you know you're under oath? You know this is under penalty of perjury. Wait till I finish the question and then you can answer. I'll wait till you finish your answer before I start the question. If we talk over each other, it's difficult for the court reporter. It's the same thing we do. It's almost like a script at the beginning of every deposition because we want the witness to know and don't want to trick the witness. We don't want them to say later, I didn't understand how this was all working. I didn't understand that it was under oath. So we have to confirm all this on the record.
Or however you wish to be responsive to my questions. Because we have a court reporter, she needs to understand what you're saying. Do you understand?
I understand.
Okay.
You're allowed to nod. Just as
You're allowed to nod. That's what her lawyer just said.
well as say yes if you want to.
I understood that as well.
Among such penalties,
So now he says you're allowed to nod your head as well as say yes. So sure, you can do whatever you want with your head as long as your mouth is saying the answer. That's the point. Come on.
to which you are going to be subject for the penalty of perjury. I want you to know the definition of
Big
perjury.
word.
Perjury is defined as willfully and contrary to an oath administered, stating as true a material fact which you know to be false.
That is very interesting that on the record, they read her that definition and now she is in trouble with perjury, potentially in 3 different jurisdictions. That is very interesting to me that they read her that in depth of a definition, because she knows what perjury is. She can't claim ignorance.
Perjury is a crime. Do you understand?
Yes.
By saying, okay, the penalties for perjury
1.
are set forth in the California Penal Code. Everything said during your deposition will be taken down and transcribed by the court reporter. Every question we ask, every answer or comment you give, everything said by your attorney or this attorney or that attorney or that attorney or that attorney. You have, I think, 5 attorneys here. Everything said by any attorney will be duly transcribed. Do you understand?
Yes.
You've got 6 attorneys.
If therefore, I'm sorry, Mr. Hardy, did you say something?
Just noting for the record,
Noting for the record what?
how many attorneys you have,
He's
and how many-
already-
or maybe you have 7.
If it therefore is vital
So Amber Heard's lawyer keeps piping in and taking shots. And he's like, well, you have 7 lawyers.
that if any time you do not hear or do not understand any question, Ms. Heard, you tell us at once so that we may have the opportunity immediately to repeat or rephrase a question to you.
I understand.
Obviously, if you do not promptly tell us otherwise, we'll have no choice but to presume that you did clearly hear and understand each question and that your answer to each question is based upon such complete and full understanding by you.
All right, I understand.
Please also remember that the court reporter can record the words of only one person speaking at a time. So allow time for the question fully to be completed before you begin to respond. If you inadvertently are interrupted before you finish your answer, please tell me immediately. Otherwise, we will assume that your answer was complete and you had nothing further to say on the subject. Do you understand?
Yes, I understand.
And don't interrupt her also.
Oh my
Let
God.
the record reflect Mr. Harder interrupted petitioner's question.
Let the record reflect her lawyer interrupted me by telling me not to interrupt her as I was telling her that hopefully she won't get interrupted. This is depositions really can be so annoying when the other lawyer is miserable. It's so much better. People are always like, do you want to go against a crappy lawyer or a good lawyer? I'd always so much rather go against a professional, very good, highly skilled lawyer because the facts are what they are. The law is what it is. Let us just do battle. All these other shenanigans make it so much more annoying.
Respondent's questioning to say the statement, don't interrupt her also.
The record already
At the
heard it. You don't
conclusion
have
of
to
this
repeat everything
session, the
I say.
reporter will transcribe what has been said into booklet form. You will have an opportunity to read that booklet and make any changes in the form of substance of the answer to any question you feel necessary. Be advised that at the time of this trial, you will be questioned before a judge as to why you made such changes. And we will contend at trial that your memory and recollection here today are as good or better than at any later time. Can you think of any reason why you would be unable to provide me with accurate and comprehensive answers today?
No, I cannot. However, I do have a question. I didn't want to interrupt you.
Oh God, she didn't want to interrupt. Bless her heart.
What you were saying. I have a question
Please.
about that. What do you mean by having to go back and or having the option to go back and change anything I say? Why would I do that?
So she's explaining in a errata sheet where if you make an error, like I was born on August 9th. Oh, I was actually August 8th. I don't know why I said August 9th. My true birthday is actually August 8th. You can go back and fix that. What you can't say is he abused me on 7 different occasions. Like, oh, actually, I want to take that back. He didn't abuse me at all. You can't make changes like that.
Is it about perhaps remembering?
She's just trying to be difficult at this point.
She's like, I'm going to tell so much truth here. I'm not going to
So,
need to change it. Why would I?
Can you please repeat that last few
Sure,
lines?
I'm happy to.
Clarify.
Thank you.
At the conclusion of this session, the reporter will transcribe what has been said into booklet form. You, Ms. Hurd, will have an opportunity to read that booklet, that transcript, and make any changes in the form or substance of the answer that you give here to any question that you feel necessary. You should know that at the time of trial, you will be asked before a judge as to why you made any changes. And our position will be that your memory and recollection today are as good or better than at any later time. Do you understand now?
Until I approve the booklet, yes. Is that the correct?
Would you like a moment to speak with your counsel, Ms. Hurd?
I'd just like to say something. The point is you want to be as thorough as you can as to the question.
That's good for
and
Johnny
accurate
Depp's
as you
lawyers.
can, so that you don't need to make any changes. You want to be as complete in this record as possible.
Okay. All right. Thank you.
Thank you.
Something
Can
her
you
lawyer
think
should have
of
already
any
explained to
reason,
her
Ms. Hurd,
during
why you
Depo
would
prep.
be unable to provide me with accurate, truthful, and comprehensive answers today? Okay. Have you ingested any alcoholic beverage in the last 24 hours?
No.
Okay. Have you ingested any alcoholic beverage in the last 30 days?
I'm going to object. I instruct you not to answer. I don't think it's relevant. I think it's invades her privacy.
He's right. It doesn't invade her privacy, but he's right.
Are you
It's not
going to answer
relevant.
my question, Ms.
I'm going to
Hurd?
take my counsel's advice.
Okay. Ms.
Her
Hurd,
lawyer's right
have
there.
you ingested
That is not relevant. That's phishing. They're going to use that for something else. They would dig into it. It is not relevant. It's not illegal to drink alcohol. If you drank alcohol in the last 30 days, it does not affect your ability to testify. That is the relevance of these questions. Drugs or alcohol the last 24 hours, that may make your memory a little slower or foggy, or you're not able to understand questions because you've ingested drugs or alcohol. That's why you ask the questions, not to dig in to see when the last time she drank was.
any amphetamine called Provigil in the last 24 hours?
I'm going to object. But I'll allow you to answer.
Object, but I'll allow you to answer this one because she is allowed to ask that. Any of these drugs, and that's a very specific one. I'm wondering where she got it. She probably has the prescription or from Johnny Depp, some information that she knows that Amber Heard is taking this. You are allowed to ask these questions about the last 24 hours. Again, does it affect your memory during the deposition?
What does that mean?
For the record, Provigil is what Kate James testified to, that Amber took 3 times the amount of and went from doctor to doctor to get prescriptions.
Yeah,
it is an amphetamine.
So that's an interesting point made by Incredibly Average, that this was actually an amphetamine that Amber Heard potentially was abusing or taking more than she should have. They have that information. They know that information. That's why they're asking.
So basically, it's an upper. And Kate James testified that Amber would take roughly 3 times the amount on a regular basis, and then take a whole bunch of wine, and it would take a lot of wine to knock her out
Take a whole bunch of wine.
at that point. So
What does that mean?
I'm going to state an objection for the record. I think it invades privacy. I think it's irrelevant, but I'm not going to instruct you not to answer.
Oh,
It's
I
up
see
to
what
you.
you're saying.
yeah, you still have to answer.
I take my medicine as prescribed by my doctor every day.
Not an answer. All 3 doctors.
Does your answer mean that the truth is that you have taken the amphetamine Provigil in the last 24 hours?
I'm also going to object vague and ambiguous and assumes facts not in evidence and calls for a legal conclusion on the characterization
Of medication.
of the medication, because you keep calling it amphetamine, but I'm not a doctor and I don't know if that's accurate.
I in fact don't even know what it is.
Let me
exactly.
assure you, Ms. Hurd, it is an
She was in the
amphetamine.
process
Sorry,
of
please don't interrupt.
Oh, wow. Look at that face. I'm sorry, please don't interrupt me. That is kind of brutal. That's kind of brutal as a reaction. I mean, you can just tell there's like steam coming out of her ears.
About me.
Yeah, that's what I was getting at, Blair, because you instructed her to be sure.
That is really like, that's such a weird facial dynamics. I mean, her vibe is so much worse during this depo than it was at trial. I know a lot of you watching this thought it was horrible at trial. This is much worse, and a jury would have liked this much less, in my opinion, than even how she was at trial.
To give a complete answer, but yet you're
And look at
interrupting
that.
her. and
Look at
that's a
the
problem for
look.
me.
Looks could kill.
Well,
right?
it's a problem for me too, so let me very clearly and unambiguously apologize to you, Ms. Hurd. I did not intend to interrupt you. I want you to be able to give full and complete statements, okay?
I would like to.
Have you taken the drug Provigil in the last 24 hours?
I have taken my medication as per my doctor's instructions.
When you refer to medication, is that medication to which you refer the drug Provigil?
I take all prescribed medication as prescribed to me by my doctor.
Prescribed as prescribed.
And I think my medical,
Information? What is she trying to?
my medical advice from my doctor is private.
Let the record
It's not a big
reflect
deal.
that
It's not.
the-
There's not a protective order on it at this
Any
point.
medication.
Petitioner, Ms. Hurd, has not responded to the question. On behalf of Mr. Depp, we will move to strike as non-responsive.
I'm just going to object. I think your last
This
sentence
is brutal.
Necessary. I think, Blair, honestly, you're being harassing to this witness intentionally. You're trying to rattle her.
She couldn't be slower, more calm and respectful. Now, is it a little disingenuous? Of course. I apologize. My deepest sympathies, Ms. Hurd, but she's being very professional. I think she's doing a great job. She's just asking questions, give her the answers. Amber Heard's trying to evade some answers. She just wants the record to reflect that she's evading the answer. Is it a step probably further than you need to go? Maybe, but she's well within her right to do that.
Whatever she says, whatever the record is, it is. You don't need to make your own commentary every time she gives an answer. And I think that
Technically, I think he's true. She doesn't need to give her commentary. The record can reflect, or they can argue to a judge later that she was evading the question or not answering the question. That's fine. But what she did was also not improper or harassing at all. It's technically true.
it's harassing and it's bothersome.
I can assure you, Mr. Harder, thank you for your comments. I can assure you I have no intention to harass Ms. Hurd. I asked her a direct question to which her response, unfortunately, compelled me to make an objection for the record because it was non-responsive. I will
Blair's a
ask
damn
again,
beast. She's
Ms.
not having
Hurd,
it.
in the
Honestly, you don't have to make that objection. It's not a proper objection for a deposition to strike a statement that I'm aware of. This isn't a trial. If you didn't want it to come in a trial, you object and say, Judge, we don't want them to be allowed to read that into the record, or we don't want, if they're playing this video deposition, she can cut that part out or argue to the judge it should be cut out because it's non-responsive. That to me seems like the more appropriate time to figure this out, but whatever.
last 24 hours, have you ingested the drug Provigil?
I Apologize if you feel I did not answer your question. I feel as though I attempted to answer your question as best as I could while maintaining the integrity of my private medical information.
We'll just leave it at that. You've asked it 3
Trying to
times.
like out
And
lawyer
I
a lawyer.
also do not feel comfortable with what do you want me to call you, Blair? I'm sorry, I didn't ask you.
That would be
Let's go
fine.
with
Trying to look
let's go with
meek.
Ms. Burke.
Miss Burke? Okay. Miss Burke,
Do you mind if I call you Blair? That would be fine. Her lawyer, call her Miss Burke. It's like the guy is he's trying to be a bulldog. You know, people really want a bulldog lawyer, and he's going to try his hardest to be a bulldog. Doesn't come off well. In my
I feel
opinion.
the way that you characterized it was perhaps I felt uncomfortable with how you characterized it. It's my medical history, and I feel there's something private and personal about that. And I also want to protect the integrity of my personal medical.
So I wouldn't have been as calm and slow as Blair. I would have said, Ms. Hurd, we have a right to know if anything's going to affect your ability to testify. You just agreed you're not a doctor. Your lawyer agreed he's not a doctor. We need to know what medications you're on so that we can have our doctors look at it to see if there actually is something affecting your memory, affecting your ability to answer questions, because that could be a very important thing in this case. That I would have just gone off on a dialogue like that by myself, saying, this is why we're doing it. This is why we need it. It's not about protected medical information. It's about what are you on? Can you answer these questions? Is your memory sufficient here for this deposition? And you guys already agreed you're not doctors. That's what I would have said. It's more to this point. It's more hammering a nail than just trying to catch bees with honey, like I think Blair is trying to do. And she's doing a very good job of that so far. But I would have been a little more direct about it personally.
Information. However, for the record, I would like to say I take my medication as prescribed by my doctor and nothing else.
Brutal.
Let the record reflect
Oh,
that on
my
behalf
goodness.
of Respondent Mr.
We're not
Depp,
even
we
through
would
the
object.
initial instructions of a
Client-
deposition.
The petitioner has been speaking for a number of seconds now, not in response to any question posed, and we would move to strike anything she said after the last refusal to answer the question. And Ms. Hurd, I would like to ask you about any other medications you've ingested in the last 24 hours.
Okay. Are you finished or are you going to keep? It sounded like you were almost finished and maybe you weren't. I didn't mean to interrupt.
Counsel, if you do not have an objection
Oh, I do.
or an instruction
I
to your
do.
client, could you please remain silent?
I thought you were done, Blair, and then it sounded like you maybe weren't done. I was trying to get in an objection.
I like how he tells Amber Heard to call her Miss Burke or whatever, but he continues to call her Blair. It's interesting. And he keeps interrupting after saying, don't interrupt her.
My objection is this. I'm going to object on grounds of privacy and confidentiality. There's not a protective order here. Her medical history is not at issue. And
They're not asking for her medical history. Like that's what I'm saying. That's why I would have cut all this out with that explanation from the jump and continue to hammer it home as to why this stuff is relevant. We get it in every deposition we ask these questions. Every one. Now, in some depositions, we have information that they are on stuff. In other depositions, we don't have anything. So when they say no, we just keep moving it along.
Case. She feels uncomfortable telling you about her medical history. You may have to make a motion to compel if you want to get into medical history. I think we should just move on and let's talk about the issues in the case.
I would ask that counsel, for the record, make no speaking objections. And if there is an illegal...
What she means is don't testify, okay? You can make your objection, say confidential private information, whatever, which is not actually a deposition or an objection they can make during this deposition or at this point, but whatever. Give your one objection phrase and move on. Don't testify.
objection, I invite counsel to make it for the record. But I would also ask, I don't want to assume, Mr. Hurd, but will you be I'm sorry, Freudian slip. Would you, for the record, would you be defending Ms. Hurd as her attorney in these proceedings?
I'm defending her right now.
Okay, I just want to make clear, I will assume that any and all legal objections will be made by you today. and not
Well,
any of the other 7 lawyers.
No, you
Uh,
actually
here.
said earlier that all the things that everyone says on the record is going to be part of the record. So
Right, I'm asking just so that we,
So is this what this deposition is? These two lawyers just fighting on the record? I thought we were actually going to get some stuff from Amber Heard out of this. I mean, I know we got some TMZ stuff, right? I mean, she's wearing the same outfit. It's got to be this Depo, right? I guess I could be confused, but let's see.
can have a clear record and any appropriate objections can be made, that Ms. Heard pick one lawyer from her team to defend her in this deposition and make for the record any legal objections.
Okay, I
That is my request.
I understand your request. I will be making objections. If anyone else feels that they need to make an objection, I'm going to let them speak for themselves.
Ms. Heard, have you ingested in the last 24 hours any non-prescribed medications?
No.
Ms. Heard, have you ingested in the last 24 hours powder cocaine?
No.
Harassing.
Ms. Heard, can you tell us,
No, it's not.
as you sit
Absolutely
here,
not.
the
If they have reason to believe she's on drugs, they can definitely ask that question. We ask it to people we don't even think are on drugs. Have you ingested any illegal drugs? Any alcohol? Any medication that could affect your memory? We ask those questions. We ask people some kind of, personal questions or questions that are really digging in because they have to answer them and they're relevant. Now, we ask them in a very nice way, but you still have to ask them.
and let me explain. It is very common in these proceedings that we just determine whether you have had any drugs or alcohol, whether anything would affect your ability to tell the truth today or
Good
impair
job by
your
the lawyer.
ability to tell the
Finally,
truth.
yes.
Okay, so
And she's answered all those questions. She's
Okay.
answered about medication. She's answered about non-medication. She's answered about, is she capable of giving
She
her best
hasn't really.
testimony? You've already covered all that. It's harassing at this point that you keep going over and over and over the same grounds.
Mr. Harder, are you making a legal objection?
Yes,
Okay,
it's
could you
harassing.
make that?
I said harassing, but I don't think that you got my message, so I want to be a little clearer.
Mr. Harder, you continue to make speaking objections which are inappropriate and improper in these proceedings. I will ask you once again to refrain from doing so. And I will ask you, Ms. Heard, one more time to answer my question. Could you tell us if you have ingested any medication whatsoever in the last 24 hours?
Objection. Invades privacy, confidentiality.
Ugh, this is brutal.
Irrelevant, harassing, asked and answered many times now. Those are all legal objections.
Ms. Burke, I feel I have answered your question. I have taken absolutely nothing that is illegal or that should impair or alter my ability to engage in and be fully present and competent during today's discussion. Sorry, can you not hear me, Blair?
Blair?
I just
She
want to make
must-
sure you heard me. It seemed like you were talking.
So she feels disrespected. She calls her Blair. She says, you were talking to somebody else. You must not have been listening to me. Just again, this is how you know you're already under somebody's skin. Not a good thing to do to a very experienced lawyer who's taking your deposition.
Did you hear me?
Ms. Heard, did you receive a deposition subpoena to be at these offices yesterday at 10 a.m. for a court-ordered deposition?
What do you mean by that?
Were you aware
Because you were
that
late.
you were ordered by the court to be in these offices for a court-ordered deposition yesterday at 10 a.m.?
No, she didn't receive anything.
I didn't.
We went in on an ex parte application
And I
and the court ordered it and she was advised of the court's order. But she didn't receive a deposition subpoena.
Objection. It appears that another
Literally, they just answered the question for her. You're not allowed to do that. Even if she didn't receive anything, she just has to answer that. Lawyers cannot do that. It's totally improper. I have heard horror stories of family law cases, and we're getting a little picture of what it's like.
individual representing Ms. Heard is now
The
testifying for
individual
Ms.
has a
Heard.
name. His name is Mr.
And
Conley.
I would ask that anything that was just said be stricken as
All they've done is interrupted each other, by the way, after they started at the beginning saying, don't interrupt each other.
responsive and moved to strike as non-responsive Ms. Hurd's answer. Ms. Hurd, I asked you a question about whether you were aware you were supposed to be here in these offices yesterday at 10 o'clock for a deposition.
I'm going to object on grounds of privilege. If you learned of anything through communications of counsel, it's privileged, and I instruct you not to answer.
Ms. that you had a scheduled deposition yesterday.
If your understanding was from communications with counsel, I instruct you not to answer. It's privileged.
Ms.
Not
Hurd,
really.
did you communicate with Jody Gottlieb yesterday?
Exactly.
I believe I did. I believe so.
What did you say to Jody Gottlieb when you communicated with her?
I don't remember what we talked about. We talked about, we talk about many things, Jody and I.
Of the many things you talked about with Jody Gottlieb yesterday, could you tell me one thing you talked about with her?
It misstates her testimony. You can answer. Although I believe it's been asked and answered. She said, I don't recall, but if you now recall, go ahead.
I don't recall the specifics. To answer your question, Ms. Burke, I don't remember specifically what we talked about. We speak often, text often. When I say speak, I'm including text messages. I don't actually think I spoke on the phone with her. I meant I communicated with her. But I don't remember exactly about what.
Did you, do you still have those text messages?
You mean on my phone
Yes.
or on my different? I'm sure I do.
Okay. Did you bring your phone with you today?
It might be in the car.
Okay. Would you be able to retrieve your phone if we took a quick break?
I'm going to object to that.
Okay.
Why?
Let the record reflect that counsel is instructing his client not to retrieve the requested evidence.
I just said I'm going to object to that.
Ms. Hurd, did you preserve all of your communications with Ms. Gottlieb from yesterday?
Objection, vague and ambiguous is the term preserve.
I'm happy to rephrase. Have you
Those are not-
destroyed or deleted any of the text?
Form. Object. Form. That's what you say. I object to the form of the question. That's it.
Messaging you referred to earlier that you undertook with Ms. Gottlieb yesterday?
No.
So every communication you had with her by text is still on your phone?
What do you mean by
From
every
yesterday?
From yesterday?
Yes.
I'm sure it is, unless, yes, I'm sure it is. I can't imagine why it wouldn't be.
I don't know what that word is. Okay. Were you informed? I'm sorry.
I was just asked if I could please have some water. Sorry. I didn't mean to.
Is it water?
Are you ready to go forward?
Yes, of course.
Okay. Were you aware that you were asked to bring documents today in response to a deposition subpoena for records?
No, I was not instructed.
Don't disclose communications with counsel.
When you say you were,
I have the documents.
We have
I mean, all the documents that we're producing in connection with the notice of deposition.
Can we have them, please?
Sure. Let the record reflect that I'm providing all documents that were requested pursuant to the notice of deposition for my client, Amber Hurd.
Let the record reflect that Ms. Spector provided me with about a 2-inch stack of documents that are in no particular order that I can see. We will go through them and we will determine whether they are responsive to the document production request.
That's Laura Wasser you're
Ms.
hearing.
Hurd, was
Yeah, that is Laura Wasser, and that is such a frustrating and just dirty pool move by lawyers. Here's a stack of papers. Good luck. Find what you're looking for at the deposition. No time to prepare. No time to actually look at them and use them for your questioning to seek the truth, figure out what's going on in the case, get some answers, figure out the facts. It is so frustrating, and you can see how annoying lawyers can be in litigation. If you ever wonder why family law cases are so expensive and take so long, this is why. If you ever wonder why I like contingency fee agreements so much, this is why. I feel like this lawyering is so bad and is so accepted in America today generally when sides just try to, and I don't know these lawyers specifically, and I'm not saying anything about anybody individually, but if lawyers just delay and do this stuff to bill more hours, take longer, frustrate the process, it's horrible. Contingency fee lawyer is in step and in line with their client because the more the client gets, the more the lawyer gets, the bigger the settlement, the bigger the or not the percentage is the same, but the number of attorney's fees are bigger, the bigger the settlement that the client gets. The quicker it settles, the better for everybody. They're more in lockstep than any lawyer that's being paid hourly. Not that there are not great lawyers that get billed hourly. I have to qualify everything I say, but for the most part, contingency fee is the best way to go, in my opinion, if a lawyer is willing to take a case on contingency. They're taking the risk with you.
You asked to provide any copies of text messages that you had in your possession for these proceedings?
I'm going to instruct you not to answer if you learned anything from counsel. It's privileged.
I will take my counsel's advice.
Ms. Hurd, was it your understanding that in conjunction with your deposition, your understanding, what you understood to be true, that you needed to provide the text messages between you and other people related to these matters?
If you developed your understanding from communications with counsel, it's privileged, and I instruct you not to answer.
How else would I? How else would
Did
I?
you say something, Ms. Hurd?
You said, how else would I?
Did you provide any text messages to your attorneys in
Fair
response
question.
to anything
It's not privileged.
that was asked of you in these proceedings?
It's privileged. Anything
not
that you
privileged.
give to your attorneys, anything your attorneys give to you, words that are said,
Okay.
written, oral, any of that, it's all privileged. You can't answer.
Whether or
I
not
would
you
object
provided
again
evidence
to counsel
to your lawyer is not privileged.
testifying and continuing to articulate speaking objections. And I want to make clear, Ms. Hurd, I'm not asking about anything anybody said to you. I'm asking about what you believed you were doing and what you understood you needed to do. Did you ever have an understanding that you needed to provide texts, copies of texts that you had undertaken between you and John Depp?
It's the same question and it's the same instruction. If your understanding is based upon communications with counsel, it's privileged and you cannot answer.
Ms. Hurd, have you preserved all of your text messages in conjunction with this matter?
Objection is to the term preserved, and as to the term all, and as to the term this matter.
Form.
It's vague and ambiguous.
Form.
It's
Object.
preserved.
Form.
Simple.
Ms. Hurd, are you going to answer my question?
I would like to know what you mean.
I
I would
wanna-
like to know, sorry.
No, go ahead, please.
Ms. Burke, I don't know what you mean by preserve, because does that mean keep, save? Does it mean intentionally, unintentionally?
Very good. I want to make sure you understand what the definition of preserve is.
I understand the definition in
Okay.
In normal context. In this
I
specific
meant it
context.
in normal context.
In this context, I don't actually know what you mean.
Okay.
I'm sorry.
Since you
Seem
filed
genuine.
for dissolution from Mr. Depp on May 23rd, 2016, have you deleted any communications in text form between you and any other person?
No.
Okay. Have you, since you filed for dissolution in this matter, May 23rd, deleted any emails between you and any other person?
Yes. My inbox fills up, and I'm told that it is best to delete messages. You don't need any more everybody votes very much.
Have you deleted since May 23rd any emails you received or sent to Jody Gottlieb?
Not to my knowledge. I don't remember doing that.
Have you deleted since May 23rd any emails you sent or received to Raquel Pennington?
No, unintentionally, not to my knowledge. I don't remember.
When you say in response to my question, not intentionally, does that mean you may have deleted emails between you and Raquel Pennington?
I'm just going to object because I believe her answer was more than what you just said. So you're mischaracterizing her response. She said no, not to my knowledge, and then she said more. So you're leaving that part out, which I think is the first and most important part of it.
Counsel
Meaning I
testifying.
haven't deleted anything relating to.
One of the reasons you can't do that as a lawyer is you're tipping your client off as to what you want them to say. You're basically coaching them. You're telling them how to answer. It's totally improper. I would be super frustrated as well if I was taking this deposition. And again, it's all on the record, so you can show the judge this later, but it's annoying having the judge play like mommy or daddy with two siblings fighting like this.
This matter for any intentional purposes or reasons other than just the normal. When you
It's a fine answer.
are
Just
done
cleaning up your
communicating
phone.
with someone and they
That's
say,
fine.
"Well, you don't need that email anymore. You erase it. It's space in your inbox."
Does your answer mean, Ms. Hurd, that you may have deleted emails between you and John Depp, or you and Rocky Pennington, or you and Jody Gottlieb because you felt like you didn't need them anymore?
Okay, I'm going to object. It misstates her prior testimony.
It's asking a
very
question.
Compound. It's vague and ambiguous.
Form.
Ms. Hurd, did you not understand my question?
No, I understood, but I agree with my counsel.
Well, if you understood,
It's just so bad. Yeah, that's the point. If she understands, she has to answer. He's not instructing her not to answer. She says she understands, so then answer it.
my question, can
That's
you
all you
answer
mouth.
my
Oh my
question?
God.
I agree. I understood your question, but I agree with my counsel and understand his advice as it relates to it.
Meaning he's
Well,
coaching
you're
me
not-
and I'm picking up on his coaching. And therefore, I'm not going to answer, which is exactly why you can't do this.
Not advice, it's just an objection for the record. And it was also asked and answered. You previously asked.
Was it your understanding that you were to provide copies of any of photographs requested?
Sorry. If you learn from counsel's privilege, instruct not to answer.
Maybe we could make a general objection that if you hear it, if you've heard anything or understand anything from counsel, Ms. Hurd, that you don't have to answer that question because it's privileged.
As opposed to tipping her off every time you don't want her to answer a question, which is what he's doing. That's a great point right there.
No, let's have an understanding that you're going to stop asking her for privileged information, and then I don't need to make the objection.
She's not.
Because
You need to calm down, Mr.
I'm
Harder.
fine. Thank you.
Okay.
Mr. Harder looks.
I am happy to make clear that I'm asking, as I have been consistently for about the last 10 minutes, Ms. Hurd to tell me about what her understanding
And it's
was,
privileged.
which is clearly not privileged.
Yes, it is. If she learned from
Okay.
counsel, it is privileged.
Let
If you
her,
want to go to the court and brief it, we can do that. But you're asking her to give you what communications between counsel are, which develops an understanding. So that's privileged.
Ms. Hurd, were you aware that on May 20, 2016, your husband, Johnny Depp's mother died?
Vegas to time.
What?
On
He's objecting to
May
every
20,
question.
2016.
So annoying.
Were you aware that your husband, Johnny Depp's mother, had died?
So I understand. Are you asking me if I knew on that date or if, sorry, I'll wait till you're done.
No, you don't have to wait.
Well, it's distracting for her, obviously.
And I just want you to hear my answer.
I am listening, and I invite you to answer my question.
We'd love to. I have a question though, so that I understand and can answer
Maybe
But now, which is funny, they could just do that all the time if it annoys her. It's like, just talk to counsel because they're allowed to be working while they're listening to her answer, which is getting typed down, and they're going to be able to read this deposition later. She can't have all eyes on me and be so offended if the lawyers are discussing something while the depo's happening.
when we're on a break, you can ask your counsel,
I
but
wanted to ask you a question.
can you answer my question?
I'm trying to.
Okay, what's your
I don't understand what you mean.
So you and Siri don't understand what I mean. When I ask you if you knew on May 20 that your husband's mother had died.
Are you
Okay.
asking me if I knew on that date or if I know she?
That question couldn't be simpler. Did you know on May 20 that she died? If you didn't know on May 20, say, no, I didn't know that. Found out later. Very easy.
Died on that date. That's what my.
Let's
I'm trying to
start.
clarify.
Let's start, Ms. Hurd. Did you know at any time on May 20 that your husband's mother had died?
I do not recall when I was made aware of that.
Fine.
fact, nor do I recall what the date was that she actually passed away.
Okay.
That's why I want to clarify.
Am I correct, Ms. Hurd, that on May 20 you had already contacted a divorce lawyer?
I don't remember the date that I first contacted a divorce attorney.
And it's well,
Is it
Your
though?
testimony here today that you do not
brutal.
remember when you contacted a divorce attorney?
Yes, off the top of my head, I do not remember when the first time I contacted a divorce attorney was.
Okay. Was it before, to your memory, do you remember when you learned Mr. Depp's mother had died?
vague and ambiguous.
I don't remember the date
It's not.
that I received this information. I know I learned about it from my parents on a text message, but I don't know what date that was off the top of my head.
Do you still have that text message?
I don't see why I wouldn't.
Is that yes?
It's exactly what I said. I'm sure I do. I don't know why I wouldn't.
If asked to provide that text message, would you agree to do so?
I'm going to object. Don't answer.
You know what's interesting about this? So, and why I'm getting so frustrated, a lot of you watched 6 weeks of this trial. It is a much different world when a judge is actually there making decisions. You would never hear this tone and argumentative voice and improper objections. I mean, we did hear some of that, I guess, during the Johnny Depp trial, but this is to another level. He would not do this, I hope, in front of a judge, or he'd get shut down immediately.
And we'll deal with it in the normal course, which is you make a request for production and then we respond to it. Anytime they ask for information, that's the protocol.
I need a mega
If
point.
I could ask you.
She's
if
still
you
allowed to
did
ask
not
that question.
delete That text message, I would ask you to.
And maybe
keep
some
or
lettuce.
preserve it. Do you understand? Would you do that? Ms. Hurd, I want to talk to you about the events first, immediately after May 21. As you sit here today, do you have a very clear memory of the events of May 21?
Are you asking me if I have a clear memory of it?
That's
I heard you
exactly
right.
what I'm
That's
asking you.
repeating
Vague
her
and
question.
ambiguous as to the year and vague and ambiguous as to
Guy's
which
brutal.
events you're referring to, because in 24 hours, a lot of events can occur. Vague and ambiguous.
Ms. Hurd, did you understand when I said May 21, what year I was referring to?
No, not until
Not until what?
It was just made clear.
And what do you understand now after your attorney speaking I was referring to?
Yes, I am clear as to what date you mean.
Okay, and what date do I mean?
May 21st, 2016.
Thank you. Do you have, as you sit here today, a clear recollection of events on that day?
It's vague and ambiguous. It's compound. There are a lot of events that happen.
Ms.
It's valid-
Hurd, do
it's
you
valid.
remember anything that happened on May 21?
I do. I remember when Johnny smashed the phone into my face.
Objection,
remember.
non-responsive, move to strike.
I,
My question to you was, do you remember anything from May 21? Do you?
wait, hang on. You asked her a question, she answered it, and now you're moving to strike her answer. That's ridiculous. You can't do that.
Is that an objection, Mr.
Yes,
Hurd?
I'm objecting to you moving to strike when she gives you an answer that's responsive to your question.
Ms. Hurd, I'm
Technically, I
asking you a
agree.
yes.
I mean, if she's going to answer like that, then she's got to take the answer. If that's the question you're going to ask, that's the answer she's going to give, then move on to the next question. Again, if it's going to come out in trial, you can strike it later. But right now, I think you got what you asked for, and now just keep moving on and see if there's anything else she remembers about that date.
Or no question. Do you remember anything that happened on May 21st, 2016?
Argumentative and harassing.
I answered that question.
And was that yes?
I answered your question already.
Okay.
Yes.
Am I correct that on May 22nd, 2016, you signed documents for dissolution of your marriage?
Yes.
Calls for leave.
So May 20th, his mom dies. May 21st, whatever just happened there, 22nd, she files for divorce.
Was that yes?
Yes.
Okay. When you signed those documents for dissolution of your marriage, was that before or after you went to a birthday party?
Vague and ambiguous.
It's form is the
don't
proper
remember.
objection.
Vague and ambiguous.
You don't remember what, Ms. Hurd?
I don't remember if it was before or after the birthday party.
You went to a birthday party on Sunday, May 22nd, correct?
I did. That's Sunday. Yes, I went to a birthday party on Sunday for my friend Amanda because I was responsible for bringing her birthday cakes as per her husband's request. That was
Just stick to the
And you couldn't, nobody else could possibly handle that task.
question. You don't
Sorry.
need to.
Cakes.
Coaching her. Wow. Just like openly coaching her. They should have done this during prep. You have your opportunity to prep with your client before the depo starts.
But I just wanted to point out that it was my job to bring a special kind of cake.
Okay. Thank you for telling me about the special cake. My question to you
Gosh.
was, did you sign documents for dissolution of your marriage before or after you went to the birthday party?
Again, I don't remember.
Okay. What will be marked as respondents A? Do you recognize this picture?
I do.
Okay. And is that a picture of you at this birthday party?
Yes, it is.
Okay. Do you have any cakes in your hand?
That's
In
come
this
on.
picture?
Yes.
I don't
The
know. I
picture doesn't
had.
show her hands.
It's
If you know, Ms. Hurd.
harassing.
Yes.
Harassing.
I don't know if there's cake in my hand at this
Okay.
moment. I do
Okay.
not.
Before,
Can I see your hand?
before you,
But the birthday party lasted for a few hours, and actually I was there for many hours. So I don't know if
This is so cringy. And I don't know if it's the client taking on the personality of the lawyer. It feels like that. These lawyers are the ones I feel like making it even more contentious. I know a lot of you are probably going to think the lawyers are taking on the personality of the client, but this is not good. This does not look good at all.
at what point I held cakes or.
The question was about this photo at this
I
moment.
remember this moment because we had to place hair over my eye to cover my black eye, and everybody at that party, 15 people at that party. 12 of
objection,
which
motion to
were like-
strike.
Stop interrupting the witness,
non-responsive.
I
please.
can only do one at a time.
You asked
Let
me.
her finish her answer,
You
please.
asked me specifically to not interrupt, so I would appreciate the same.
Go ahead.
I
Please,
think
please
I
finish your
am,
answer.
I would like to finish my answer if that's okay.
Finish her
Thank you.
I remember this photograph because we had to place hair over my eye. The eye typically get hit on, because of the nature of, would it be a right hook? But I specifically had hair placed over my eye to cover a bruise and swelling and scratches on that side of my face from the cell phone incident when Johnny smashed the cell phone into my face. So my friends here in this picture took great effort to make sure hair was covering my eye as to not set off media attention and media storm.
Are you finished, Ms. Hurd?
With that answer, yes.
Objection,
Ugh.
non-responsive.
This is annoying
move
too, though.
To strike the entirety of Ms. Hurd's answer.
And I'm
They
just
are
gonna
probably
say
doing
all these
that
motions to strike are
to annoy her.
ridiculous, and we will take them up with the court.
We'll
Right, I
go
mean-
off the record.
I do think that is annoying too for Johnny Depp's lawyers to do that. All of you are probably going to disagree with me, but in a depo, you shouldn't do that. And this whole environment that's been created is not the way we're supposed to handle ourselves. It's not professional as lawyers, in my opinion.
You-
At this
The
time,
question, before we go off the record, the question,
Microphone.
the question
It's okay,
had
we don't
to,
have to go off the record. We have
the
to agree to go off
question
the
had
record.
to
I can
do,
only take one person at a time.
the question had to do with this photograph, and the answer had to do with this photograph.
We don't have to go off the record. We choose not to.
We're not going off the record, we're staying.
We'll stay here. We're still on the record.
You still rolling?
Yep.
All right,
Great. You're still on camera, so.
okay, I understand. Yeah, I remember this. In
Okay,
fact, they
don't
both,
talk though.
Okay.
Love you.
all right, that's fine.
Did he say love ya? Kind of weird. That was an awkward reach, but he was grabbing the mic head, I guess, and covering up the microphone. But that was they're very close. Kind of weird. I will just tell you, I would never do that with a female client of mine during a deposition. Reach across her blouse to cover up the mic.
Oh.
I know.
You're on. hand it to me.
Yikes.
I know. Oh, you want to take this?
I'd
So
like
that
to
you know
also-
that if I hear it, if I hear it, I have to write.
And I have enabled myself as well.
Oh, wow.
You may want to just refrain from speaking if you don't want on the record.
We're starting now.
Okay, all right, sure. I'll check my purse. Do you guys like any water? I'm gonna get up and get one. Would you like one?
Fine, thank you.
All right. So that is the end of part one. This is what you all sent me. I didn't know if it was going to be the whole depo or chunks of the depo or how they were going to do it, but apparently they are going to do it in chunks and in parts. And we will keep pulling them whenever you guys send them to me. And I'll do reactions. If you're interested in this kind of content and want me to do actual reactions and talk about the legal angles and the objections and what's proper, improper, how this stuff looks and whether or not it's normal for a lawyer to see stuff like this. But you all keep sending it. Twitter and Instagram, follow me on here at Tragos Law. That's where I got this video from. Incredibly Average. One of the followers that's a mutual follower of ours tagged me in it. So if you guys find more chunks of her deposition, I will continue to react to it piece by piece. Let me know your questions again in the comments or during the live chat. Hopefully you guys enjoyed this. Until next time. Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.